Thank you. And now the Honorable Judge Zane Pētersone from the Supreme Court of Latvia and the representative of the European Association of Judges of Mediation.
Good afternoon, ladies and gentlemen. I'm very happy to see so many faces today here in the conference who are, I hope, very much interested in mediation. And I hope so quite a lot of more interested persons who could be at their screens and also hopefully following the conference. My presentation will in some way actually contribute to the previous one, telling how the situation is in Latvia and how about for the next mediation, how is it going on, and what are the difficulties, what we can do in future. Of course, we know the most well-known division of mediation models that we also have in our documents, official documents by our government. So there are free mediation, court annexed mediation that exists since 1st of January 2015 in Latvia for civil matters, court mediation when you get a mediation in the court, this system we do not have yet, and integrated mediation, let's say in the sense that the judge can mediate his or her case himself or herself. Actually, in the conception of 2008, Latvian government supported all 4 types of mediation in Latvia, but concentrating efforts on the first 2 models. But it is not forbidden for a judge to use mediation methods in his or her own work as well. The court annexed mediation in Latvia means that every judge in civil matters has duty to suggest to parties option for mediation. It is mandatory at 4 stages. Firstly, when the claim statement has been submitted to the court, it's immediately duty of the court to send information on mediation to both parties and ask them if they would like to use mediation. If positive responses are gained, then the judge adopts a decision to postpone the case up till the time limit of 6 months in order for parties to try to use mediation. If at this stage parties have not replied, yes, we would like to try mediation, then the judge has a duty to suggest that again when preparing the case for trial. If also then it doesn't work, then during the preparatory hearing, if there is one, and for sure during the main hearing. And I guess we have the most opportunities to do that exactly during the main hearing. Before the judge sees parties, the only way how to persuade them is in written form. So what do we try to send? We send a list, one piece of paper from both sides, where is concentrated information on mediation, on benefits of mediation, and also where the parties can find a list of certified mediators and where parties can get more information on mediation. As you were told already, we have a list of 38 certified mediators at the moment. In October, when the new certification process will go on, we'll have more mediators, certified mediators, I hope. And this is what the judge can use when parties ask, okay, we say, okay, we agree, we will go to mediation, but where shall we go? Before January 1st, 2015, this was a problem. If I talk to parties and they agree to go to mediation, where do they go? So the list of certified mediators help because it is in every court. Every judge can give parties a list. They can choose from these mediators. On our list, we have photos of mediators because it, of course, can help in order to trust the mediator and to choose a mediator. We have the region in which the mediator is working. We have working languages of mediator. We have the main civil dispute fields in which the mediator, with which the mediator works with. And of course, contact details. So quite a lot of information that a party would need at that particular stage about the mediator, and to gain some more trust in mediator, and to see that it is a live person and not someone who could endanger his or her integrity. Why mediation, court-annexed mediation, is still not working as well as I would like it to work? First, of course, it's a new thing, but and for new things, it takes time for the process to work. However, I would say it's a mixture of different reasons. The first thing, of course, it's new. There's a lack of resources or money from the state. Mediation law, we started to work on mediation law in 2009, when the economical crisis struck Latvia, and the green light for starting the law was only with the preconditions that not a single, at that time, lat would be needed from the state budget. So now the situation is different, the crisis is over, and if we want mediation to work, the state has to contribute to that. I will tell a bit later how. Lack of education for society, for lawyers, for judges, lack of motivation that is closely connected to the first reasons, and lack of enough knowledge about mediation, and quite a lot of myth about mediation in people's minds. When I talk to judges why to refer parties to mediation, I firstly ask them a question, what do you think our mission is? What is the mission of a judge? And I get rather surprised that majority of judges do not have an answer like that. Why are we there? Not parties are for us, but we are for them. So our mission is to help them in the best way possible. Then we talk about satisfaction for a judge. Because in Europe, I think for development of mediation, judges have been very much supporting this development of mediation. Because when you see a case, sometimes you feel that you can make the best possible judgment, but it will not help the situation. It will not help the parties. And when do we get the satisfaction? Then when we have written a very nice judgment? Not necessarily if it doesn't help the conflict. So we are much more happy when people go away happy. So usually I start talking with judges about this why to refer. And the next question is when to refer, because not necessarily in all situations they need mediation. And it is important for the judge to understand, firstly, for himself, if this particular dispute should be better solved by mediation, or by arbitration maybe, or by court, or maybe it's enough with negotiations, or maybe with conciliation, what we have experienced so far, just with the help of advocates. How really to understand which one is better? I suggest judges keep to such stages. At first, they need to make a conflict diagnosis, type escalation, and to understand what is the conflict. Then to clarify parties' interests. Pretty much the same as mediator would do, right? Then I would say clarify the best option to solve the conflict for himself, so he can understand, to put together the conflict and parties' interests and to see what do they need. When the judge understands what actually parties need, then he or she can try to explain this best option to the parties and to refer parties to this best option. How to do it? Not really that easy. I would say it is judges also need a lot of training in order to do that. And my future wish is that we will have these trainings for judges. At the moment, they're very limited because of limited resources for Judicial Training Center. Latvian Judicial Training Center is trying to do all things possible to have at least one seminar a year, but it's not enough for judges. We have about 600 judges, so we definitely need more training. What do I say? How to refer parties? To persuade or to allure? I really like the word allure here, because if you push too much something to someone, you get resistance, right? I prefer asking questions and not telling them, you know, it's so good for you to go to mediation, mediation will help you, mediation is so good, so good, so good, so good. Not necessarily. I prefer asking questions. Questions like, if you get a judgment, would that help to solve your conflict? Will the court be able to solve your problem? Sometimes people do not understand how much resources litigation can really require. So also I can ask about these things to parties. Do they understand how much money, time, energy, nerves the litigation will ask from them? There are many different points parties have never ever thought about. So these questions can help parties really to understand that it could be better to try mediation. Rights or interests. People in the court are so much focused on their, I have the right to claim this. So also judge at this stage, similarly as a mediator in mediation, should focus on interests and not so much on claims or the rights of parties. So I would say that the techniques are quite similar to the mediator's techniques. And also skills. Also the judge, when referring parties to mediation, should gain parties' trust, recognize parties' emotions, gain information, summarize information, and see possible solutions. And at the very end of my presentation, I would like to speak about some myths about mediation that are very much alive and that are obstacles for the mediation to work. Of course, these are not all myths, and there are some myths that are widespread among lawyers, myths that are widespread among judges. There are myths that are widespread in society. However, maybe these ones are more or less for everyone. And quite popular is the sentence that I really, really don't like. And the sentence is, mediation doesn't work. Court annexed mediation started officially on 1st January 2015. It's just January. In April, I hear from judges, mediation doesn't work. I say, really? And what have you done for mediation to work? Is this an alien mechanism that just acts by itself, or it needs people to stand behind that and to put it to work? So this is the first myth, and mediation, if it is going to work or not, depends on all of us, each of us. Is it going to work or not? Mediation is not for parties in conflict, also very much widespread myth. If they really do not have any conflict, and if they have just dispute on interpretation of laws, then they do not need mediation. Then they need either negotiations or judicial decision. But when parties have conflict, then they need mediation. Mediation is not successful if there is no agreement signed, another myth. Because it could be quite dangerous when statistics are being shown somewhere, because also mediation that doesn't end with a written agreement doesn't mean that there haven't been any benefits. Because people could try to understand each other better, they could collaborate better, they could understand each other better. And I have seen that in my court settings. I had like a huge case, and when I sent them to mediation, they come back. They haven't concluded the agreement, but it was quiet. They had already shouted during mediation. It was much shorter, easier, and also part of the claim, the party took back it. So it was much better and easier for me as a judge and for parties also among themselves. And the last myth, there is no mediation possible now if it had already been tried before and had not brought the parties to an agreement. Like judges could say, why should I propose mediation to them if they had been to mediation already before coming to the court? They didn't agree, so why should I refer them to mediation again? Because things change. And they can change every day, and even more every month, and even more every year. Because when they started the dispute, and when the judge sees parties in the case, could be like 6 months later, 1 year later, and conflict is a dynamic procedure, it can escalate and it can de-escalate. So you don't know, if you don't try to see at what stage their conflict is at the moment, that it's the same as it was before. So it doesn't mean that the mediation cannot be successful now. And for my hopes for future, I really hope to have mediation officer or mediation desk in every court. Why? Because I can do all my best to talk to parties and to allure them into mediation. And when they say, yes, okay, we are going to mediation, but they don't speak to each other, how are they going to agree on a mediator, even if they are given a list? So mediation officer or mediation desk that we have seen in some other European countries would really help, to my mind, because officer could take them from the court room, advise them from the list on what their interests are, to advise them, let's say, 3 or 4 mediators from that list, to call them, to find the time and place where the parties should be, to agree with mediator and parties immediately there in the court, because then the parties do not need to see each other or before, and there's much more chances that the people really will come to in the designated time, to the designated place, and something can happen. Informed society, we need much more information for society. We need cooperative lawyers, and I would say actually in Latvia, advocates are cooperative to a very large extent, and much more than maybe in some other European countries. Of course, there are exceptions, but to a large extent, our lawyers are very progressive. Our advocates are collaborating very much to development of mediation. And at last, educated and well-trained judges and court staff that could also help for us to refer people to mediation. This is very shortly about how things are at the moment for court annexed mediation in Latvia. Thank you very much, and I would like you to bring one thing from this conference home, and this thing is mediation, and the future of mediation depends on each of us. Thank you.